Hello, everyone, and welcome to One Civil Law. So for today's stream, I just wanted to give a few clarifying remarks to my stream I did yesterday relating to Karen Reed's federal case because there were some questions in the comments and some points that I thought could be clarified, and I thought I might take a moment to try to expand on some of these concepts. So the first being that, as some of you guys have correctly noted, as I watched the live stream chat replay, that there's already a hearing scheduled on the federal docket. And I said the court wouldn't even hear the case. And so I'm understanding that you guys were saying that because you were perhaps misunderstanding what I was saying, or I was not expressing what I wanted to say correctly. So there is this idea in federal law called abstention doctrine, where, as I mentioned, the federal courts will abstain from hearing certain kinds of cases. So when I said the federal court might not hear the case, what I was trying to say is that they'll ultimately decide to abstain from taking on the case. And the fact that they have these preliminary hearings doesn't really speak to that one way or another, right? These are preliminary hearings in service of many things, one of which is to decide whether or not the federal court will hear the case. So I never expected them to just, wave it completely off the papers on its blush. That's something that obviously could happen, but not my expectation. So they're going to have a hearing basically to decide whether or not to hear the case. And we've sort of seen that kind of thing happen before. We've seen it, for example, when it comes to jurisdiction. For those of you guys who were here when we did the whole Katie without a crystal ball versus Toddy Westbrook case, right? Like, can the court even hear the case? Do they have jurisdiction? And there were a lot of filings in that case, as I'm sure you guys will well remember. And there were hearings and all the rest of it, right? The court spent something like a year trying to decide whether or not they could even hear the case, with hearings and arguments and papers flying all kinds of directions before ultimately deciding that, no, actually, I can't hear the case because I don't have jurisdiction. So the fact that there's hearings, these preliminary hearings, doesn't necessarily mean that the court will, in the end, decide that it can or wants to hear this case. So I thought I would clarify that. So I still think the odds-on favorite is, in the end, the court will abstain from hearing the case based on ex parte Young and other doctrine. The other thing, they set the hearing so quickly. Now that hearing date sounds about right, based on federal rules. So the fact that the hearing was scheduled on when it was didn't strike me as particularly odd. That struck me as perfectly normal procedure. So that they want to have a first hearing on it on like the 5th or something, I'm like, yeah, that didn't strike me as weird or exceptional anyway. So it didn't really say anything to me, but that was to me. And they said so fast because the trial is looming. Also that, yeah. So the federal court, to the extent they're trying to expedite things, might be expediting it because they're aware that there's a clock in the background. So they might be trying to expedite this because of those reasons, but the timing didn't strike me as odd. The other thing that I thought was worthy of clarifying on this issue is the procedural posture that we're in, because that's a huge issue, and I sort of alluded to it as I discussed it, but I perhaps didn't discuss it in enough detail. We're on a writ of habeas corpus, and that is a very limited role for the federal court. There's something called the Anti-Terrorism and Effective Death Penalty Act, the AEDPA, which basically construes and constrains the federal government's ability to use habeas. And essentially, the federal courts only use habeas when there's clearly established federal law. So they don't really establish new federal law, not in habeas proceedings. They establish new federal law in direct review proceedings. So if this case ever winds up at the Supreme Court on a direct review someday, we appeal directly from, say, the Supreme Court of the state to the U.S. Supreme Court on a direct review, then we're in a different posture. And the Supreme Court might, at that point, make decisions based on a direct review, but we're not in a direct review. We're in a collateral proceeding, right? Strictly speaking, we haven't appealed to the district court because, strictly speaking, you can't appeal to the district court, right? You're basically doing a collateral attack. You're attacking it from the side. You're bringing a new case that says this other case shouldn't be allowed to proceed, and that's a collateral attack. And collateral attacks are generally disfavored in law, and habeas proceedings are no exception. Habeas proceedings are constrained. So you're looking for basically a clearly established federal law that says that this is a violation. And obviously, as we sort of discussed, I wasn't really able to find one. There was some precedent that was cited by the plaintiffs in their filings. There was one First Circuit case, and there was that Ninth Circuit case we kind of discussed that kind of looked like, maybe there's something there, but it just didn't seem direct enough for my taste. It's not really, or more the point, based on my assessment of what I see from the courts. They don't really go out of their way, especially in live proceedings, to interrupt live proceedings. So sort of the factors sort of counsel against it in multiple deference. Is there a legal issue for someone filing an amicus brief in the district court? No, not really. Someone could file an amicus brief if they wanted to. It wouldn't be unheard of in a district court proceeding. Unusual, but not unheard of. No, so that'd be fine. Yeah, and then there was this exchange I had with someone in particular that I thought I'd go through in detail because, there's a couple comments I thought I'd respond to just to clarify some points. This person, the Fulchman, said, why would it not be an equal protection argument? If double jeopardy is a federal constitutional right, which certainly it is, then if one judge asks for partial verdicts and another doesn't, the accused with the second judge is not receiving the same benefit of double jeopardy. And to which I responded, that's not necessarily a bad idea, but of course the petition we read didn't make an equal protection argument. It was rooted in double jeopardy, not equal protection. So it's I can't consider an equal protection argument that's not presented, which is why I didn't discuss it. So, I can only assess, as the court can only really assess, based on what's there. Sometimes courts will come up with new arguments, but typically not. Typically, they're just going to rely on what's presented to them and not go beyond the page. So it's pretty unusual, and sometimes not even proper for courts to go beyond. So I don't think they're going to develop an equal protection argument based on their own initiative. That seems pretty unlikely. And then there was another comment that I thought, this was interesting too. I think the defense was asking for partial verdicts when they brought the verdict forms not having separate not guilty options. Yeah, that's a different issue, right? The issue there was the clarity by which the options were presented with respect to the counts. So they were concerned that the language of count 2 with respect to the options was not as clear as it could be. So that didn't have anything to do with partial verdicts. That had to do something with, could we clear up the language so it's a little bit clearer what the jury is voting for, because we think the options are a little vague. So that was a different issue, and it was cleaned up. It was cleaned up. The jury was presented with revised jury forms as a result of that discussion with respect to count 2. So that issue was cleared up and not what we're discussing today. Okay. Michael Call End 801 said, if there's no law that prevents a judge from giving all or nothing instructions, then one of those very instructions violate defendant's rights. Well, then that would prevent the judge from doing it, right? If there is a law that says the judge can't do that, then obviously the judge can't do that. So, yeah, but it's well, if there's no law that prevents it, then how do you know they violate the defendant's rights? How do you know they violate the defendant's rights if there's no law that specifies that or clarifies that? What are you basing that off of to say it violates defendant's rights? So if there's no law that says this is a violation of rights, then how do you know it's a violation of rights? Right? So it's well, how are you getting there in the absence of precedent, particularly on this habeas posture? Isn't the judge supposed to pursue all available options? Well, they're supposed to consider all available options, yes. Would polling the jury be one of those options? Potentially, yes. It would be one of the options. So the judge may not have given sufficient consideration, and there is some precedent to argue this position. The judge may not have given sufficient consideration to all the available options by just declaring the mistrial without doing that. And we did see some citations in the petition that sort of were alluding to that argument. Now, it's interesting because in the cases that were being cited, I think it was true. It was certainly true in the Ninth Circuit case that we read in detail. But another thing you'd want to know is whether you'd want to know in the decision that the federal court was reading it, whether they were making that decision as a matter of federal rules, or whether they were making that as a decision of federal, like the federal constitution. So if you had a federal court that said, for example, look, there was a decision in which the judge did not consider all their options, they really should have, and that's a problem, right? Are they making that decision because of the federal rules and they're like, you violated a rule? Or are they saying that because it violates the Constitution? Because those are not all the same thing, right? The federal government can create its own rules just as surely as the state can. And the federal government obviously has the ability to determine its own rules just as surely as the state can. So if the federal court, when they were making that decision, was like, you violated the federal rules, bad on you, then that doesn't necessarily extend to the state level, because the federal rules are not the Constitution. So it would really only be applicable if they said, no, this is a constitutional problem, and we're making this decision on the Constitution, which incidentally, by the way, you can presume the court did not do that, because federal courts in particular try to avoid making constitutional issues when they can. They literally call it constitutional avoidance. So federal courts, including the Supreme Court, will try to make decisions based on grounds other than the Constitution if they can. So if there's an argument to be made based on a rule, based on a statute, based on something else, they're going to make the decision on that. The Constitution is sort of their last step, not their first. So you need to know whether or not they were rooting it in the Constitution. And so if it's not rooted in the Constitution, it doesn't have applicability, or it doesn't have automatic applicability to the state level decision, because federal rules are not state rules. And so what's true for the federal rules is not true for the state rules. So just because a federal court said it doesn't necessarily mean it was based on the Constitution or has applicability to state level law. Yeah. So that's interesting. Do I know what the judge was upset about when they adjourned court? Not really. It's not 100% clear. Yeah, so there's some things there. Okay. So this person said, if no law prevents the judge from giving all or nothing, then what if the instructions and violate defendant's rights? It's like, in the absence of law that says it, how do you know it's a violation of rights? It seems to me if a jury unanimously agreed not guilty on 2 or 3 counts, but are unable to submit that verdict, defendant's rights are being violated somehow. Maybe. I mean, it's not an invalid thought. It's just, why do you know that, right? Either through the exposure, double jeopardy, due process, or equal protection. Can't the Supreme Court find that even if the judge was violating mass law, they did in fact violate Karen Reed rights? Of course they can. Of course they can, but they won't do it here. They won't do it on a habeas. Because in a habeas posture, it's not, the Supreme Court has made clear that in a habeas posture, we need to look for something clearly established. So if it's like, can't the Supreme Court make a new decision that makes a new establishment? It's like, yeah, they can, but they probably are not going to do it on a habeas posture. They're not going to pick this up, as a result of this. They might pick it up in a direct review, but I don't think they're going to pick it up as a collateral, given the rules that define habeas as defined by the Anti-Terrorism and Effective Death Penalty Act. I don't think they're going to pick it up. So, yeah, that's my best assessment. But they could someday. I don't think they will, incidentally, but maybe. We'll see how it goes. Oh, also, there was a comment. I finally figured out why people were giving me a hard time in chat when I said I'd take either side of this to the Supreme Court, of this issue to the Supreme Court, because for me, this is a pure legal issue, right? It's a pure legal issue about this double jeopardy issue, right? And so when I said, for example, that I was a mercenary and I'd take either side of this argument to the Supreme Court, it's because for me, this is a pure legal issue. And it's like, I think the Commonwealth is probably correct on this legal issue. So it's like, I could defend the Commonwealth on this legal issue because I think they're correct. That doesn't mean that I think that they're right about other things. It doesn't mean that I think that they're right about prosecuting Karen Read in some broader sense. It doesn't mean that I think they should be prosecuting her. It doesn't mean that I think there's sufficient evidence to prosecute her. It doesn't mean any of those things. It just means on this pure issue of double jeopardy, I think they're right. So if the Commonwealth asked me to take this on their behalf to the Supreme Court, I'd do it because I think they're right, especially given the precedent, especially how we control habeas proceedings and so forth and so on. So, I take it because I think they're legal. I think they're on the right end of the law as best as I can determine. And if, Karen Read's team asked me to take it up, it's like, well, it's a novel question. It's a novel question and she's the underdog, and that's always fun. And so that's an interesting posture to be into, even though I expect to get my teeth kicked in. So it could be fun, even though I expect to get my teeth kicked in. So that's why I said what I said. It's like, I wouldn't want to prosecute Karen Read. I wouldn't want to be part of the prosecution team. But as an appellate lawyer, right, I'm asking very different questions than as a trial lawyer. And so I tend to think like an appellate lawyer. And so that's what I said before. What are the odds the April 1st Karen Read trial will be delayed? I think the odds are pretty decent. The trial will be delayed. It seems like we're trying to do a lot in not much time. So, I think the odds of it being delayed are pretty decent. What else was there? Yeah, someone said, if you want to lose your ever-loving mind, look at the interview Turtle Boy did with one of the jurors. That's always sad when jurors are like, juror's gonna juror, though. It's just the best system we have. So juror's gonna juror. Yeah. Let's see what else we got going on here. Does discretion require a reasonable consideration? Yeah, probably. Right. So I think this is sort of the best chance that they have, right? The best chance they have with the federal court is simply the idea that the judge did not give sufficient consideration to all the alternatives. And by failing to do so, that was a problem. And there is that one case that was cited. I think it was a First Circuit case at that, where there was that federal judge and a federal jury who was not keeping in place with the rules. And so there is one case that kind of speaks to that proposition. So there is that one. It's a little bit thinner than I'd like. I mean, obviously you want a little bit more robustness in your case law, but it's not nothing. So it's not frivolous, right? Karen Read's argument isn't frivolous. She does have an argument that has something to it. It seems based on the complete collection of things that seems like, on balance, that doesn't seem like it's going to be sufficient. But if a federal court is really looking to go out of their way to do this, then maybe there's a hook there. So maybe there's a hook if they're really looking for an excuse to get involved. But I just don't think on balance, on the legal analysis, that's a favored position. I think it's a disfavored position. So I don't see it working. It's not impossible, but I did think it's disfavored. So let's see. Yeah. I like how someone in chat said, is this a liberal channel? Is this a liberal lefty channel? Lol, no. It is decidedly not a liberal lefty channel. No, I'm very conservative. I'm extremely conservative. No. I'm a conservative through and through, man. Which is one of the reasons, incidentally, like I like rules so much. That's one of the things that defines conservatives as a category. Like conservatives tend to like rules. Left-leaning people tend to not like rules as much. The conservatives like the bounded. They like rules. They like order. They like organization. Left-leaning people are more determined, are more likely to be more free thinking. They're more likely to be open-minded. They're more likely to be, willing to break barriers and boundaries and so forth and so on. So no, it's like, I like rules, man. Rules are good. No, I'm conservative through and through. So it's like rules are good. I like rules. No, yeah, that was a fun comment. Yeah. No, I'm conservative through and through. Okay, and then there was there's this argument, or this one that said, this guy Justin Tharp said, and no, Judge Bev, the Supreme Judicial Court, or otherwise cannot override Karen Reed's U.S. constitutional rights with state court statute either. You're absolutely correct, right? The U.S., the state rules and the state statutes and the state everything have to bend to the federal guarantee. So you're absolutely right. Supremacy doctrine, no problem all day long, right? So if in fact this is a violation of our Fifth Amendment rights under the U.S. Constitution, then, obviously the state can't say, but no, though, right? If it's true, then the state can't say, but no. It's like, no, but yes. So if there's a federal guarantee, no state statute, rule, regulation, determination can interfere with that. That is true. Yeah, because supremacy clause, 100%, no doubt. State laws cannot conflict with the Constitution because the Constitution is the supreme law of the land. It's true. That's true, right? It's absolutely true, no doubt. This is established by the Supremacy Clause in Article 6, Clause 2 of the Constitution. I'm trying not to be insulted that he's explaining this to me like it's the first time I've ever heard of it, incidentally. I'm trying really hard to not be like, I'm being explained like constitutional basics. It's like, I'm well aware, but, thank you. The Supremacy Clause establishes the Constitution, federal laws, and treaties are the highest authority. Yes, that means federal law takes precedent over the state when the two are in conflict. This is known as preemption. Yep. The Supremacy Clause applies to all state courts and constitutions. Thank you for this exciting information. Thank you for this exciting information. That's good news. Yes, that's all those things are true. Noted. Yeah, and then this is why I was commenting about this earlier. Like Stephanie Yates said, according to Aussie, the appeal court, and strictly speaking, not appeal court, but I don't blame you. Strictly speaking, it's not an appeal. It's a collateral proceeding, but that's okay. The appeal court has already started a date for their first hearing. And I said, sounds right for a preliminary hearing. Court may still abstain in the end, though. We'll see how it goes. Yeah, so the fact that there's a hearing doesn't mean they're going to hear the case. And that's where the confusion came from, right? I was like, oh, they're not going to hear the case. And you guys said in chat, but there's hearings. And I'm like, yeah, there's hearings. And I didn't really figure out until after chat why you guys were saying it, right? I didn't really figure out until afterwards why you guys were saying it. It's like, wait a second, you're saying they're not going to hear it, but there are hearings. I'm like, I understand the source of the confusion. Yeah, they're preliminary hearings, at least in part to decide whether or not they're going to hear the case. So they may decide not to hear the case even though there are hearings. There may be many hearings. There could hypothetically be months of hearings. I mean, there won't be in this case because of time, but right, there could be very long proceedings trying to decide whether or not we can hear the case. It could go on for a while, at least hypothetically. We've seen it happen. So yeah. Oh, this one is good. This is the same guy, Justin Harp, 5652, who wants me to read this very carefully. Okay. Because whoever informed you the federal court doesn't have, presumably, any federal laws that ground them to the United States constitutional laws was about as wrong can get. Okay? Yes, federal law must be in line with the Constitution. That's true. Federal law also has to bend to the Constitution. The Constitution is the supreme law, so federal law also can't be unconstitutional. That is true. Explanation. The Supremacy Clause establishes the Constitution as the supreme law of the land. That means that federal laws and treaties must follow the Constitution. This is true. Thank you for explaining it to me like it's the first time I've ever heard of it. Federal laws must be within the constitutional parameters, which are the powers delegated to the federal government. Federal laws cannot violate other constitutional limits, such as the Bill of Rights. Right. The Supremacy Clause also includes the idea of judicial review, which means the courts can overturn unconstitutional laws. I agree with you. I think Marbury versus Madison was correctly decided. I think it's correct. I agree completely. The Supreme Court has the power of judicial review, which it uses to protect civil rights and liberties. Yeah, all those things are true. All those things are true. Yeah, all those things. And I simply said, I know all these things. What exactly do you think you're correcting me on? It's like, what are we talking about? So he says, so you never made the claim that you've never heard of a federal law that supports Karen Reed's constitutional rights. No, I did make that claim. I haven't heard of a federal law or a federal decision or a federal precedent that covers Karen Reed's position. That's exactly what I said. I'm not aware of one. I mean, there could be one. There could be one, in which case, yeah, I mean, obviously, if there were precedent that applies in this situation, then, fair enough. I mean, obviously, that precedent would potentially read on this situation. We might have to get into the fact specific to see exactly how close it is, to be fair. But yes, I mean, obviously, if there's a federal decision that would control this situation in this posture, then yeah, of course, I'm just not aware of one. And the closest they came was that one First Circuit decision. I'm like, I don't know if that's going to cut it, but okay, at least it's something. But yes, maybe I misunderstood your position, a point where you came to federal law conflicting with the U.S. Constitution. I don't know that I ever said that at least in the context of this discussion, I haven't said that there's a federal law that conflicts with the Constitution, so I'm not sure where that comes around. But okay. He says, Kurt, if you go back to around 8 minutes or so, you're evidently making the claim that neither state law nor federal law is required to follow the U.S. Constitution insofar as the no double jeopardy clause. And it's like, no. It's like, if you go back to that timestamp, what I said is, and I guess we can watch it rather than me summarize it, but we can watch it real fast. I won't necessarily readjust the margins to make them pretty, but I'll show you what the timestamp is, and then I'll re-explain it because that seems fair. Why can I not hear anything? Oh, I muted the audio on my tab. That's why I can't hear. It means. That's why I can't hear anything. I muted my tab audio. That was stupid. All right, so let's go back to 8 minutes and watch this segment, and then you guys can see what he's talking about. What that means as to what the comment to the rule means, that's purely a matter of state law because it's a state level rule. So whatever that commentary means in the state level rule is purely an issue of state law because it's a state level rule. So if you think if you interpret that rule to mean the court must do that, there's only one person you can talk to, the Supreme Court of Massachusetts, because they're the only ones who can determine what the state law means. Correct. And in their decision, they didn't say anything like that. So it must not mean that. It must not mean as a matter of state law that the court's required to do that. The commentary to the rule must simply be a misstatement of the rule. It must be, because the Supreme Court of Massachusetts is the ultimate guide as to their own state law. There's nowhere left to go. It's the end of the road as to state law. So it must mean that. So, okay, so it can't mean that it's required as a matter of state law. So is it required as a matter of federal law? It's like, show me a federal decision that says it. I can't find one. Right. So literally every word I said there unsurprisingly is true. Right. Literally every word I said there unsurprisingly is true. Yeah. The state is the ultimate judge of its state law. Yeah. That's the end of the game. When you're trying to determine what the state law means, the ultimate authority is the Supreme Court of the state. That's the end of the game. And yeah, there's nowhere left to go. That's completely true. So if you're trying to decide what this Massachusetts rule of criminal procedure means, that's obviously a state level rule. It's the Massachusetts rule of criminal procedure. So the state is the ultimate authority of what that rule means. Right. And the federal government can't do anything about that as far as the state level understanding of the rule is. Right. All the federal government can do is say, okay, given that, taken as a given, is it in conflict with the federal law? Then if it's in conflict with the federal law, then sure, that's a problem. But they can't just provide their own exciting interpretation of state law. Right. They have to take the state law as a given. And then they determine whether there's a conflict. But yes, everything I said in that, unsurprisingly, is completely true. The Supreme Court is the ultimate judge of federal law. States are the ultimate judge of their own state law. In the event of a conflict, the U.S. Constitution makes clear that the Supremacy Clause means the federal Constitution wins. So, yeah, but yeah, that's all those things are true. So, yep, that's what I said was very correct. And yeah, all those things. Let's see what where we picks up. So I said exactly what I said was exactly correct, and yeah. So where was this thing? Where we pick up? All right. So I say, so he says, if you go back to 810, you're evidently making the claim that neither state nor federal law is required to follow the U.S. Constitution. I'm not making that claim at all. I'm simply making the claim that whatever the state law means is a matter for the state Supreme Court. That's all the claim I'm making. I'm not making any claim that given that it can't conflict with the Constitution. That's not at all what I'm saying. Yeah. And so you'll sure go back and watch it for yourself. I did, and no. You seem to be claiming that only the Supreme Judicial Court can conclude whether or not the judge is required to render about a partial verdict otherwise in the Karen Reed case. Insofar as the state level rule is concerned, you bet your ass. Insofar as the state level rule is concerned, you bet your ass. Only the Supreme Judicial Court can make the decision as to whether the judge is required to render a partial verdict as to its own state level law. You bet your ass. Now, obviously, the federal court can say it's required as a matter of the federal court constitution, but that's a different thing. But you understand that every Supreme Court justice also swear an oath to the United States Constitution. I'm sure you understand what it means to swear an oath to uphold something. You're essentially bound by that path, correct? Yeah. I mean, we do want to uphold the U.S. Constitution. That is true. That is a good thing to do. So, yeah. Which means you must adhere to it. That's a primary part of your civil duties, a judge, a Supreme Court justice, or a federal judge. They all have to abide by the United States Constitution. We're all on the same page. We are. Yes, we understand. Everyone has to obey the United States Constitution. You also claim that you're wholly unaware of any federal law or precedent. I'm adding or precedent because I'm not aware of any that supports Karen Reed's constitutional double jeopardy clause and due process rights. Correct. I haven't really found any that seems to work. On a habeas posture, because of how narrow it is, it doesn't really seem to work. That is, you're asking to see the federal law that would require the jury to render a verdict, partial or otherwise, on Karen Reed's behalf. Yeah, I'm absolutely asking for that, because if it's a matter of federal law, can you show it to me? Right? If it is a matter of federal law that the jury is required to render a partial verdict, can you show me the federal law? That would be really helpful. I'd like to see it. But you understand the federal laws must adhere to the Constitution, and Karen's no double jeopardy clause is in fact a U.S. constitutional law. Yeah, no one is disputing that there is a double jeopardy clause that absolutely is a thing. The question is, what exactly does the double jeopardy clause mean in this context? As I'm sure everyone here is more than well aware, there are oodles and oodles and oodles of decisions discussing the U.S. Constitution and every one of its provisions in so many decisions, not only at the U.S. Supreme Court, but even more importantly, at the Court of Appeals, where all the real law is done anyway, because they hear so many more cases than the U.S. Supreme Court. So there are so many cases, right? So many cases clarifying or discussing exactly what is double jeopardy. What exactly is this thing? What does it mean? In so much detail. We've got shelves. Do you like double jeopardy cases? I got double jeopardy cases out the ass. I got shelves and shelves of double jeopardy cases. How many double jeopardy cases do you want? We got so many double jeopardy cases. It will fill your life with joy, right? There are so many of them. But yes, it's like, can you point me to the one that says that Karen Reed wins? Like, can you give me that case? And that First Circuit case is kind of the closest they've got. And I'm like, okay, maybe there's something there. I mean, that's a thing. It's not exactly on point. It's not exactly, one for one, but it's something. I mean, it's a comparable. As Karen Reed's lawyers, I definitely cite it all day long. I have no objection to them citing it. It's like, this is something that sort of is vaguely in the same ballpark, or maybe not that vaguely, depending on your point of view, but like, is it enough to get you home? I'm like, I don't know that it is. I don't know that's enough to get you home. It's like, but yeah, We're trying to figure out what the double jeopardy clause means exactly, particularly again on a habeas posture where review is much more narrow and much more limited. It's pretty self-evident in the video here. You're claiming you're not aware of federal law that exists to support the no double jeopardy clause cited within the U.S. Constitution. I'm aware of so many double jeopardy decisions. I'm aware of many double jeopardy decisions. I'm just not aware of any that work here. I'm not aware of any that work for Karen Reed. I'm aware of many double jeopardy cases, lots of them, shelves full of them, just none that work here. But you're apparently telling me right now you're well aware that both the state and federal law have to abide by the U.S. constitutional law when it comes down to legal proceedings. I am very well aware of that. I know the state has to follow the U.S. constitutional law. I just don't know where there's a court that's ever said it in this or a context that seems to work. You know, it's like, okay. So that can mean you understand the judge must inquire about the judge's verdicts. So that could only mean you understand the judge must inquire about the jury's verdicts in order to ensure her right standing with Karen Reed's constitutional rights and her own constitutional oath, correct? No, I don't understand that. I don't understand that judge must inquire. I don't understand that. I don't understand that partial verdicts are required. I don't understand that. I don't know of any case that says that. I don't know of any case that says partial verdicts are required. As a matter of federal law, I don't know that case. None has been cited to me. The counsel for Karen Reed don't seem to be aware of that case either. They don't seem to be aware of the case that says, yes, you must do partial verdicts. That'd be good, but you know, that case doesn't seem to exist. So, you know, okay. And it's essentially what Karen Reed's defense is arguing in this case. The courts ignored Karen's constitutional rights, which evidently is a deprivation of Karen's constitutional rights. Yeah, but they're arguing it without precedent. They're arguing it without real clear precedent, and that's sort of the issue, especially on the habeas posture. It's like it would be nice if it were true, but why is it true, right? It's like, what is your authority for this proposition? And this guy's like, but the Fifth Amendment, though. And I'm like, you're going to have to do a little bit better than that. Anyone who follows my channel for any length of time understands, especially as we've discussed, for example, qualified immunity, right? When we talk about clearly established federal law, right? When we talk about something being clearly established federal law, yeah, it has to be pretty damn clear. It has to be pretty damn clear. It has to be really on point. It has to be really on point. So, no, I don't think any decision like that exists. The First Circuit is sort of vaguely alluding to it, kind of maybe. On a habeas, I'm not really feeling the habeas posture here. Not really working for me. Yeah. Yeah. Because one thing's for sure, Karen Reed's right to a fair trial received harsh, uncalled for kick to the proverbial face by both the Bev and the Supreme Judicial Court. But apparently, according to the United States Constitution, that's a violation of civil law. I can't find it, though. And so I simply try to say I'm unaware of any federal law or federal case that supports Karen Reed's claim to double jeopardy. She is claiming double jeopardy means something in specific, but I can't find any specific support for her specific position. It's like, that's the problem. I can't find anything specific that supports it. Federal law has to abide to or adhere to the U.S. constitutional law. That's what federal law says. I know, which I understand you're well aware of at this point, so I think we both agree that the argument is settled. In the U.S. Constitution, no double jeopardy clause is in fact a clearly articulated and outlined constitutional law. What it defines is pretty self-evident. Wow. Yeah. That's, yeah. Wow. That's nice to know. You know, what double jeopardy clause means is self-evident. So I guess we don't really need all those many shelves devoted to this and other parts of the Constitution. Like, why do we even have precedent, though? Right? I mean, obviously, what the Constitution means is absolutely 100% clear, and there's no ambiguity. It's clear on its face what it means. Yeah, well, Among other people who would sharply disagree with you would be the U.S. Supreme Court, because they seem to spend a fair amount of time clarifying exactly what the Constitution means. If it was totally clear on its face, I'm not sure what half of the Supreme Court docket is doing. Of course, the Supreme Court doesn't always hear constitutional cases, by the way. A lot of cases they hear are just based on statute. So not everything the Supreme Court does is constitutional, but like probably half their docket is. I mean, I haven't counted, but probably half their docket is can you clarify the Constitution? And the other half is, can you clarify some statute or rule? But it's totally clear on its face, though. Oh, that's good. We don't need all those volumes of shelves. We don't need all those lawyers, man. Wow, that's a relief. Supreme Court's going to be thrilled. Their docket just got a lot easier. They don't have to hear some of the cases anymore. Jesus Christ. And obviously, the no double jeopardy is legitimately binding U.S. constitutional law. That's a relatively simple 2 + 2 from where I'm standing. I think the equation is a little bit more complicated than 2 + 2. I know you're trying to do 2 + 2 is 4, but what I'm trying to tell you is you got to break out some algebra and some calculus and some set notation and some other things that when the math is suddenly letters and squiggles and upside down letters and other marks, when the math no longer involves numbers, right? We're into math where numbers are no longer really a thing. We've moved past the number stage, and now we're into strange and exciting symbols on the blackboard phase. So I appreciate the 2 + 2, but no. So I say, no one disputes that double jeopardy is federal law. The question is, what does double jeopardy mean exactly? There are many cases that interpret double jeopardy and exactly what it means, but I can find no case that explains it means what Karen Reed is arguing it means. There is no specific support. In a habeas posture, the federal court will only intervene if there's clearly established law. The lack of any specific precedent to her position appears to be fatal to her legal claim. I mean, yeah, that's kind of true. That's kind of true. And then he wants to say, but Kurt, doesn't Karen Reed's defense clearly outline what a double jeopardy constitutional right means in this case? Well, not so much what it means as what they wish it means. I mean, it's an argument. It's an argument. It's like, well, this is what we would like it to mean. And it's like, okay, well, I appreciate that's what you want it to mean, but why does it mean that? And their support for why is a little bit thinner than you would like. All right? It's not really great. It's a lot of very aspirational, high-floating language about America and America being great and awesome and all the rest of it, and not really much in the specific. It's not super duper thrilled. The double jeopardy clause in the Fifth Amendment to the Constitution prohibits anyone from being prosecuted twice for substantially the same crime. The relevant part of the Fifth Amendment states, no person shall be subject to the same offense to be twice put in jeopardy of life or limb, meaning no imprisonment after the fact. Well, more of the point, no jeopardy after the attach, which it's even broader than that. See, like he even understates it, right? It doesn't mean no imprisonment. It means no imprisonment, no trial, no process, no court cases. It means the state goes away. That's what it means. It means the state goes away and goes hides in a corner somewhere and licks their wounds and feels sad about their life. That's what it means. If it's true, which I wholly understand we're not aware of because the jurors have not been brought in for question yet. Yeah, we're assuming what the jury members have said is true. We're obviously assuming it. But if it's true that Karen cannot be tried twice for the same offense, and jurors supposedly found her not guilty with both accounts are clearly articulated as crimes. So in fact, the jury found her not guilty of those crimes on count 1 and 3. I mean, again, like only if partial verdicts are required. Would that be true? Like, yeah, so, right, I mean, I've sort of said this before, but it's like, okay, and the rule doesn't seem to like, the rule doesn't seem to explicitly allow for this possibility, but like as a matter of constitutional law, putting aside the rule, like if the judge had brought them in and said, okay, we're not guilty as to count 1 and 3, but we're unsure as to count 2. So putting aside what the Massachusetts rules say about the issue, because we're going to do this as double jeopardy issues, right? Because we're focused on the Constitution. So we're focused on the Constitution. So we're going to focus on the Fifth Amendment. As he pointed out, obviously the rule can't supersede the Constitution, so we can dispose of the rule, right? So putting aside the rule for the moment, if the judge had said, what do you think, jury? And they're like, okay, not guilty 1 on 3. We're not so sure on 2, right? As a matter of the U.S. Constitution and the U.S. Constitution alone, could the judge have said, that's not good enough, I'm declaring a mistrial across the board? And to the best of my knowledge and understanding, yes, the judge can do that. And Bluford is kind of partial support for that proposition, because that kind of happened in Bluford, right? In Bluford, the jury came back and said, we're not guilty as to like the capital murder count, but we're a little bit unsure about this other count. And the judge said, not good enough, go back and try harder. And then the jury came back and said, well, now we don't know about anything. Now we don't know about anything. So it's like, okay, even though the jury said we're not guilty as to count 1, and the judge said, go try harder, and the jury said, okay, now we're completely hung. The U.S. Supreme Court said that was okay, right? So that was okay. So it seems logical to my mind that if in the end, in Bluford, it's like, could the judge have said, you know what, just no, and I'm saying no to it across the board. I'm not going to enter that not guilty verdict. Could the judge have done that? And I don't know of any case that says they can't. Now, again, the Massachusetts rules seem to say that if you do ask for partial verdicts, you have to enter them. So that'd be a violation of the Massachusetts rules. But would it be a violation of the U.S. Constitution? I don't know that it would be. So, yeah. That's the fundamental basis at its root or core behind the no double jeopardy clause, which Karen obviously has the right to civil protection. She obviously has the right to the double jeopardy clause, whatever it means. No one disputes that. It's like, what exactly does it mean is the issue. And all judges concerned obviously swore an oath to uphold that civil protection. Yeah, so did the Supreme Judicial Court of Massachusetts. They took an oath to uphold the Constitution of the United States. And I'd like to believe they were doing their best to uphold it. Now, that doesn't necessarily mean they get it right. The U.S. Supreme Court overrules state Supreme Courts, on federal law. But, I'd like to believe they were trying. It's not merely a relevant obligation. It's ratified civil law that's certainly relevant among many others. So from my point of view, it's clear what the no double jeopardy clause is qualifying or giving a person right to. Maybe it's not 100% black and white. It's not. But what laws really are? Not many. It's very difficult to write a black and white law. It's very difficult because it's really, really hard to, in advance, deal with every possible contingency. So, yeah, it's very difficult, and there are not many absolutes in law because it's so difficult to try to deal with every possibility for all of time. So, yeah, it's challenging. I mean, I think I'm being flexible or reasonable is a big part of the U.S. constitutional civil rights process. Well, no, as to that much, I would disagree, right? Because I'm an originalist, or perhaps I'm even more of a textualist. But either way, being flexible or being reasonable is not within my role here, and it's not how I would think as a judge. I'm not interested in being flexible or being reasonable. What I am interested in is correctly interpreting the Constitution based on its original meaning and based on its original text. That's what I'm interested in. I'm interested in making sure the Constitution means what it meant when it was written. I'm definitely not interested in being flexible. I'm not interested in a living Constitution. I'm interested in whatever the double jeopardy clause meant when it was written. That's what I'm interested in. So flexibility is not exactly a high priority of mine, no. Nor is it incidentally a high priority of the Supreme Court as a whole at the moment, as I'm sure you guys can appreciate it. But apparently Bev and the Supreme Judicial Court are not being civil in their overall determination of their civil rights. We can opine all day back and forth. The point is only can be determined by the jurors. Well, no, the jurors are the finders of fact. That's what jurors do. Jurors find facts. Courts find laws. The power of the jury is to determine the facts. The power of the court is to determine what that means. So what does it mean that 12 jurors apparently thought in their head, not guilty? What does it mean that 5 jurors apparently are saying that all 12 of us were unanimous? What does that mean? That's a legal question, not a factual question. What does it mean? Right? So, yeah, it's not really for the jury. This isn't for the jury. And that's where the problem begins. The uncivil side of law in which these two courts, Supreme Judicial Court and state, are evidently denying Karen Read her civil constitutional rights is not being in line with being civil. I don't know that's what they're doing. But once again, I'm quite certain that this is a simple matter to clear up once the jurors are brought back into be questioned. There's no law effect that says the federal constitution states this can't be done. Yeah, I mean, again, the only reason we would bring the jurors in is if it matters, right? Right? The only reason to bring the jurors in and ask them is if the answer matters. Otherwise, why are we doing it? Right? And so we're presuming, for the sake of argument, that all 12 would say, yes, this is true. Okay, what does it mean that all 12 would say it? And then if we determine what it means, then we can determine whether or not to ask them. Right? Because it only makes sense to ask if the answer matters. Why ask a question if the answer doesn't matter? So for the moment, there's no reason to bring in the jury because the answer doesn't matter. It doesn't matter what they say because that's the legal posture at the moment. That is, their previous verdicts rendered, I think, should satisfy both sides, unless one of those sides has an agenda. Okay. Because, as you say, there's no guarantee the verdicts will be wholly heartedly in Karen Read's favor. Yeah, that's for sure. We don't know what next jury is going to do. There is no predicting juries. We've seen juries. We saw them, for example, in the ice cream murder case, where the jury went from 11-1 to acquit for one jury. They hung. There were 11 votes to acquit and 1 vote to convict. So the jury hung. And on the retrial, it was 12-0 to convict. So you never know what a particular jury is going to do. You never know what a particular jury is also going to care about, incidentally, by the way. This is incidentally why, like, you have to be cautious when you're looking for advice from jurors about what to talk about, because you never know that the next jury is going to care about that particular thing. Like, a previous jury really, really cared about something, but the next jury doesn't care about that thing at all. And so you can't really use the experience of one jury to have sort of really any predictive effect about what another jury is going to do. So, you know, yeah. But it's not up to us or the courts to decide. That's up to the jurors to decide. No, it's a legal issue. It's definitely up to the courts. Because the jurors are the one who's supposed to render a final verdict on counts 1 and 3, which would ultimately exonerate Karen of those crimes according to her Fifth Amendment constitutional rights. But we can't possibly know or arrive at that matter of fact until the jurors are brought in. But at the moment, it doesn't legally matter. And the no double jeopardy vehicle certainly supports the jurors being brought back in to hear their claims on the verdicts, especially if there's multiple jurors out there claiming it. At the moment, it just doesn't matter. No rocket science. It's not rocket science, but it is law. It's complicated. There's a lot of it. There's a lot of law, and there's a lot of issues, and there's a lot of interplay. Just sound adherence, which was what I gather Karen Read is asking for. Yeah, I don't know what to do with this guy. I just don't know what to do with this guy in terms of trying to explain this. It's like, look, I mean, I'm not claiming to know everything, but I have been studying this stuff now since I started law school. It's been 20 years. So, I mean, I have been studying this for 20 years. And so, you know, I have a lot of knowledge floating in my head. And it's not to say I know everything. It's not to say I learn about new things all the time, because there's a lot of law out there. There's a lot of it. But, you know, I know a lot of stuff too. I've got a lot of things going on in my head. And so, like, I'm aware of, like, what the federal habeas posture is. I'm aware of what they do on a federal habeas review. I'm aware of this is a collateral attack. It's disfavored. You know, the Anti-Terrorism Effective Death Penalty Act. You know, we're concerned about habeas, and we don't want to use it unless it's clearly established. And then we got abstention doctrines defined by Ex parte Young and other cases, which says, you know, as a general proposition, you know, federal courts don't get involved in live state level proceedings. and so forth and so on. So you put all those things together. You put like ex parte Young and abstention doctrine, and this is a habeas, and the Anti-Terrorism Effective Death Penalty Act, and you put all these things together, and there's like, okay, I'm not sure it's going to work. Don't really see it. Don't think she's going to be able to get there. I don't even think the court's going to hear the case in the end. I think they're going to say we abstain in the end. You know, I think that's the more likely course of action. You know, now of course I could be wrong, and if I'm wrong, then it becomes down to why, right? Why am I wrong? Right? Am I wrong because the judge, and that's why you read decisions, incidentally. That's why you read them, to understand. Because I've definitely thought things before and been like, that's wrong. And then I read the decision, I'm like, oh, okay. So I've definitely been convinced by decisions before to change my mind, but that's, what you're supposed to do. So, if I'm wrong, why am I wrong? Am I wrong because I'm misunderstanding a precedent? Am I misunderstanding a presumption? Am I wrong because the court is reading some law differently than I am? Or am I wrong because the court is out to lunch, right? Am I wrong because the court is just, doing a Leroy Jenkins and running into the battle, with nary really anything behind them? In which case we're like, okay, well, that doesn't make any sense. I guess we're off to the Court of Appeals to have that reversed, right? So it's like, if I'm wrong, why am I wrong? And what can we learn from it? So those are all good things. But that's my best prediction right now. My best prediction is, I don't think they're going to hear it. And if they do, they're probably going to say that, given the status of habeas, that probably shouldn't do anything about it. That seems like the most likely resolution. This guy said, it's very disingenuous on one hand to say, I can't find a law that states it, then say in the next, yeah, it might not say it, but all the lawyers know. Either it has to say it or it doesn't say it. It can't sometimes have to say it, and sometimes we just assume. And then I clarified that because the lawyers know what a deadlock instruction means because of cases that tell us what the deadlock instruction means. There are cases that do teach that, so the lawyers should know. So when I say, like, the judge didn't say it, but the lawyers should know, I'm saying it because of things like Allen, the U.S. Supreme Court case that, said this, basically, and about the deadlock instructions. I'm like, okay, we all know. And deadlock instructions are given all the time, and we all know what they mean. And there's lots of case law dealing with deadlock instructions. There's more than a few cases about it. So when I say, like, oh, the lawyers know what this deadlock instruction means, even though the judge didn't say it, it's like, yeah, because the case law teaches us what it means. It means this is the last step, baby. It means this is the end of the road. It means we're all going home, right? So all those things. All right, this is interesting. I very much disagree with your statement about fair rules and this having to go both ways. I know over here, if you can show reasonable doubt about the outcome of a jury verdict, you get the better result for the defendant as that standard for every single step in the process towards conviction. I know it's not quite the same for you. For one thing, I know your standards of evidence are the same for both sides, but surely something so directly dispositive should only be held to a reasonable doubt standard. Well, no, the reasonable doubt standard is the standard for conviction. All right. And so it doesn't necessarily mean that this is an issue of reasonable doubt. Like, that doesn't make sense. I like this guy. Bob King says, so in other words, you don't know what you're talking about. In other words, you don't know what you're talking about. I don't know what to do with these people sometimes. I really don't. I do know what I'm talking about. I'm exceptionally well educated on this area. I'm exceptionally well educated. I read these cases for fun all the time. It's like I've got 3,400 videos on my channel discussing law. I love law. I've been studying it for 20 years. I definitely know what I'm talking about. I definitely understand this stuff. It doesn't mean I can't be wrong. I've definitely been surprised before by decisions. But, I'm pretty well educated. I'm pretty well informed. I'm not necessarily the Oracle of Delphi, but, I've got a pretty reasonable handle on things. Oh, Lord have mercy. Let's see what else we got of this. This guy, you make a joke of this. She's guilty. You are the joke. Lol. Yeah, so I thought I'd respond to a few of those comments just because, I thought I'd try to clarify this a little bit in terms of the legal posture and sort of where we're at in this thing. And, the best hope really is the idea that the judge did not sufficiently consider the alternatives to a mistrial. Right? That's your best hope, right? Because, well, that she didn't really consider it, and therefore there's some sort of error there that triggers double jeopardy. So, like, that is the most likely ground for her to win. And there was that one precedent from the First Circuit that sort of suggested that possibility, at least with respect to federal law, the federal cases. I guess we could read the First Circuit decision and see how close it is in terms of that. So we could spend a little more time, because we keep talking about this First Circuit case, but we haven't actually read it and sort of what its foundation is. So that might be interesting. So let's take some time now and read the First Circuit decision, and we can have a better assessment. Maybe my opinion will become revised and I can change my odds. Because right now my odds are like, how about 1% for Karen Reed? Right now my odds are like, how about 1%? They're not looking really good. But we could read this case and see if the odds improve from the somewhat dismal posture, and give that a shot. So let's try to do that and take a look and see if we can get anywhere with this First Circuit case. They didn't really, by the way, incidentally, really help the federal judge in terms of this. So if this case is better for them than they made it appear, they didn't really spend a lot of time and verbiage on it. They kind of talked about the case a little bit and they talked about some stuff. But if this is as strong for them as they really need it to be, they could have hammered the point with a little bit more force rather than, kind of throwing it away. It was a little throwaway if they think that this is the thing. So we'll read this for a second and see what's going on here. As I look for the case. Yeah, here we go. United States versus Toribio Lugo. You got to love some of these case names sometimes. Toribio Lugo. You gotta love these names sometimes, man. Dun, dun, dun. Doesn't the statute say if there's no evidence they can show a pattern of bias on the judge? I mean, that's a completely different argument, trying to show a pattern of bias. That's completely different from what we're trying to do right now. So, yes, hypothetically, you can try to show the judge has bias, but that is not what we're trying to do right now. Chili's done? Excellent. I had my chicken dish, and it is tasty. I was down another 2 pounds this morning from yesterday. So at this pace, if this can keep up, man, 2 pounds a day, man. 2 pounds a day, man. We can get this done in 2 months, man. It'll be great. Oh, Lord. All right, let's take a look and see what's going on in this case. All right. United States of America versus Jose Toribio Lugo. Okay. 4 days into a criminal trial, the district court discovered that a juror had been absent for some time. Right away, guys, I'm like, what do you mean? Right away, I'm like, what do you mean? What do you mean 4 days into the jury trial, the district court is just noticing that a juror has been missing? How good are your powers of observation, district court? Right? Oh my God, this juror's been missing for like 4 days. Can we take the judge outside the woodshed and beat him to death? That's what I want to know. That's what I want to know. Can we take the judge outside and beat him to death? Okay. 4 days into a criminal trial, the district court discovered that a juror had been absent, and having previously disregarded the lone alternative, declared a mistrial sua sponte. Defendant appellant Jose Torbido Lugo therefore moves to dismiss the indictment on double jeopardy. District court denied. The appeal ensued. After careful review, we conclude the lower court erred in refusing to dismiss, so double jeopardy attaches. Okay, great. And in a way that matters. Okay, cool. Now let's see. So this is a federal grand jury, and this is a federal trial. So that's important to note, by the way, because we're looking for constitutional rules, right? And so it would be really helpful to Karen Reed if it said Fifth Amendment in here somewhere. It probably won't. It's probably going to talk about federal rules of procedure and some stuff. But, you know, because this is a federal case dealing with a federal court, you know, if it's based on rules, if it's based on federal rules, then the applicability to Karen Reed goes down, because the federal rules can be whatever they want to be, and the federals and the state rules can be whatever they want to be, you know, as long as they're not unconstitutional, of course. So if it's based on rules, it doesn't really apply in a constitutional sense, but we'll see what we got. On June the 6th of 2021, a federal grand jury indicted the appellant for various narcotic offenses. The court impaneled a jury of 12 plus one alternative. Trial commenced in 2001. The alternative juror experienced a personal problem, and the judge excused her on the second day. So now we have a jury of 12, or do we? Do we have a jury of 12? At the start of the fourth day, the courtroom deputy informed the judge that only 11 jurors were present. The judge immediately consulted with both the prosecutor and the appellant's lawyers. The judge outlined two options: either postpone the trial until the 12th juror could be located, or proceed with a jury of 11. See Federal Rule of Criminal Procedure 23B2A, permitting the parties in a criminal case to stipulate to a trial by a juror of fewer than 12 at any time before verdict. I believe it's specifically 11, by the way. I don't think it's any jury less than 12, but I could reread the rule. But I think it's you can stipulate to a jury of 11. Defense counsel asked why the juror was missing, and virtually in the same breath began to express her viewpoint. She stated, "The thing I'm thinking about, that's as far as she got." The district judge interrupted, declaring, "This is very simple. The missing juror is not here. She's not here. She might be dead. She may be ill. It doesn't make any difference." Chasson, defense counsel, conferred with the client and informed the judge that the appellant did not wish to proceed at that moment with 11, but rather would like to wait for 12 jurors, a 12-member juror. The judge then immediately terminated the sidebar, announcing the trial would be postponed until the 12th juror could be found. We're going to do the best episode of Cops ever. We're doing an episode of Cops now where we're going to go find the juror. Bad boy, what you gonna do? What you gonna do when jury service coordinator comes for you? Find him, baby. Find him. Round him up. Lol. Almost immediately thereafter, the judge learned the problem was more complex than initially thought. Thus, he excused the jury and told the attorneys what he learned. The missing juror had been absent during some or all the earlier portions of the trial. This is, again, where I want to take the district judge out and beat them to death. Right? This is the part where I'm like, I want to move out of this proceeding and move into a new exciting proceeding. My immediate concern is no longer the fate of Torbido Lugo. I mean, the fate of Torbido Lugo is really interesting and all, but I'd like to move to another proceeding where in that proceeding is the beating of the federal judge. What do you mean you're just now figuring out the juror had been absent for other parts of the trial? What do you mean you're now just figuring that out? What are you talking about? Did they have like a mannequin in the jury seat? Was there a hologram? Can you count to 12? Can you count to 12? Do you know how many 12 is? Okay, that's fun. The judge then announced that they were going to declare a mistrial because only 11 jurors had heard the evidence and didn't believe there's any way to cure the defect. Well, there is, incidentally, by the way, if this party stipulate to it. as we just read in the rule. By the way, this is, yeah. The prosecutor promptly asked for a new trial date, but the judge, seemingly anticipating a double jeopardy challenge, declined the request. Defense counsel tried to articulate their client's position. She said, "Our position is that the judge once again Kidorov missentence. Counsel, wait." He then began questioning the courtroom deputy about the numbers of jurors originally impaneled. What do you mean you're asking the deputy how many jurors were impaneled? You don't know? You don't know how many jurors you swore in? You're not quite sure how many jurors you swore in? You're not quite sure what that number was? What do you mean you don't know? Cool. The shape of the fiasco soon emerged. That much is definitely true. On the morning of August the 13th, the first day of the trial, 12 jurors and one alternate were sworn. For reasons that remain obscure, one of the impaneled jurors vanished later that morning. Okay, no one, neither the prosecutor, defense counsel, courtroom deputy, judge, noticed the juror's absence in the trial proceeded. Okay, I would like to revise my previous motion to beat the judge. I would like to also now beat the prosecutor and the defense lawyer, who also apparently can't count to 12. Or 13, as the case may be. They don't seem to notice this juror is missing. Prosecutor doesn't notice. Defense lawyer doesn't notice. Judge doesn't notice. Everyone is super duper observant in this courtroom. Everyone gets flailed. Flailings for everybody. This state of blissful ignorance still existed when, on the second day, the judge, with the assent of both parties, dismissed the alternative juror, and then we're not quite sure that we still have 11. The upshot was that only 12 jurors had begun to hear the evidence, and only 11 of them had been present from the second day forward. Is it possible for me as the Court of Appeals to basically say, we're not going to redo this case because it's simply too embarrassing? Is that a legal basis for me to say, we're not going to do this case because you all have to hang your head in shame. You all go to the timeout box and hang your head in shame, and we're not redoing this case because you don't know how the basics. Is that a thing I can do as the Court of Appeals? That's what I want to know. That's what I want to know right now. Is it's too embarrassing a legal basis? That's why I want to know. After recounting this bizarre sequence of events, the district judge expressed some uncertainty about whether, in the event of a mistrial, the double jeopardy clause would bar retrial of the applicant. The judge invited attorneys to brief the issue. Defense counsel again endeavored to be heard, but the judge again thwarted the attempt. He then reconvened the jury, acting sui sponte, declared mistrial. This is not going great. Where thereafter the government moved for a new trial date, the appellant objected and cross-moved to dismiss on the indictment of double jeopardy grounds. Briefs were submitted. On September 24th of 2001, the district court denied the motion to dismiss. The judge predicated his ruling on two alternative grounds. First, he concluded the mistrial was required by manifest necessity because only 11 jurors remained and the appellant had refused to proceed with fewer than 12. Secondly, he concluded that the appellant had in all events, consented to the declaration. I'm not quite sure how you're saying they consented when, you didn't give them an opportunity to be heard. I'm not sure how that consent manifested itself, but okay. In the ordinary course, a defendant cannot pursue an immediate appeal from an interlocutory order in a criminal case. Like virtually every general rule, this rule admits two exceptions, and one such exception allows for immediate appeals on denial to dismiss premised on colorable double jeopardy grounds. This case comes with that exception. We therefore turn to the merits. So, fair enough. If there's colorable double jeopardy grounds, then maybe the district court will hear it. Maybe they will. It's possible. It's not impossible. Double jeopardy clause ensures that no person shall be subject to the same offense to be twice put in jeopardy of life or limb. That jeopardy attaches at this early stage rather than final judgment. Yes, in recognition of the defendant's prized right to have the trial once underway completed. The prophylaxis of the double jeopardy clause is threefold. One such protection restrains the government from using its powers and resources to subject a defendant to serial prosecutions, thus prolonging his ordeal and unfairly enhancing the prospect of ultimate conviction. Despite its importance, however, the protection against serial prosecutions is not absolute. Mistrials exemplify the need for exception. When a mistrial is declared before a jury returns its verdict, jeopardy may or may not persist. In other words, double jeopardy principles do not automatically bar reprosecution, and the circumstances of each case must be examined to determine where that case falls along the double jeopardy continuum. If, say, the defendant had consented to a mistrial or manifest necessity had precipitated it, the prosecution ordinarily may proceed anew. These outcomes reflect an understanding the defendant's valued right to have his trial completed by a particular tribunal must in some instances be subordinated to the public interest in fair trials designed to ensure an end in just judgments. The baseline standard of review applicable to the denial of a motion to dismiss on double jeopardy grounds following declaration of mistrial is abuse of discretion. In light of the important constitutional right involved, appellate review must ensure the trial court indulged a scrupulous exercise of that discretion. This entails in accepting the trial court's factual findings unless they're clearly erroneous, which is generally true on appeal. You don't get to fight over the facts unless they're batshit nuts. Articulation of law in de novo review. A mistake of law is a fortiori an abuse of discretion, which, fair enough, because if it's a mistake, if it's error, then it's an abuse of discretion because you didn't really have discretion at all. So yeah, if it's error, then it's an abuse of discretion because you didn't have discretion. So it must be an abuse. That makes sense. Here, the threshold determination that the appellant consented to a declaration of mistrial has both factual and legal components. Consistent with the paradigm limited above, we review the district court's factual finding for clear error. Where the facts as found add up to consent is a legal determination, right? So what happened, what did they do, and is that consent is, of course, a legal question. Cool. Like the district court, we must first inquire into the existence, vel non, of manifest necessity. After all, if the mistrial was occasioned by manifest necessity, then the question of consent becomes immaterial. Fair enough, you want to deal with manifest necessity before consent, that's fine. You can do it in either order, that's fine. The Supreme Court initially coined the phrase manifest necessity in the early 19th century. In Perez, Justice Story wrote, "The law has invested courts of justice with the authority to discharge a jury from giving any verdict, wherever, in their opinion, taking all the circumstances into consideration, there is a manifest necessity for the act or the ends of public justice will otherwise be defeated. They are to exercise a sound discretion on the subject, and it's impossible to define all the circumstances which would render it proper to interfere. To be sure, the power ought to be used with the greatest caution, under urgent circumstances, and for very plain and obvious causes." Makes sense to me. Absent attempts to define the term more precisely, beyond tautological announcement that manifest necessity demands a high degree of necessity, has not been helpful. So we've tried to, clarify this, but manifest necessity is all we've got. Right? Manifest necessity is all we've got. So that's as good as we can do. Experience teaches us there's no mechanical rule for determining whether a mistrial is or is not supported by manifest necessity. Consequently, an appellate court's inquiry invariably reduces to where the district court's declaration of mistrial was reasonably necessary under all the circumstances. Typically, this inquiry is informed by a triumvirate of interrelated factors. And again, by the way, these are factors to be applied. I'll take note. So these are interrelated factors. So these are not necessarily dispositive. These are things to consider. It doesn't necessarily mean if these things aren't present, it isn't true because as he just mentioned, right, there's no mechanical rule, right? They just said there's no mechanical rule, right? So this is not a mechanical rule, right? These triumvirate of interrelated factors is not a mechanical rule because there is no such thing. There are factors to consider. There are points of consideration. Their absence does not mean there's manifest necessity, and their presence doesn't necessarily mean that there is, because there's no mechanical rule. Yeah. So anyways, some factors you might ponder as you're considering this possibility are whether alternatives to mistrial were explored and exhausted, whether counsel had an opportunity to be heard, and whether the judges was made after sufficient reflection. Which arguably, you could argue that none of these factors are present in the Karen Reed case. You could argue that the alternative of, a partial verdict was not considered. The judge just could have said no, but the failure might be to even consider it. So the failure to consider it might be sufficient error, right? Because I talked in the previous stream about harmless error, right? That's something we talk about in law a lot. This idea of harmless error doesn't really matter because the judge could have just done it anyway. Well, maybe it isn't harmless error. Maybe the lack of consideration is sufficient error, right? Maybe it is. Whether counsel had an opportunity to be heard, which is debatable at best in this situation, that they had an opportunity to be heard. I've commented about that, but as Karen Reed's lawyer, you can certainly argue that position. And where the judge's decision was made after sufficient reflection, which is also an arguable position. So you could argue all three of these factors for Karen Reed. It's certainly not frivolous. In the case at hand, there was a clear alternative mistrial proceeding with 11 jurors. And presumably in the Massachusetts case, there might be an alternative asking for partial verdicts. That might be an alternative. Although the criminal rule normally requires 12-member jurors in criminal cases, the parties may, with agreement, proceed with fewer than 12. Thus, it's within the power of the district court to continue with 11 jurors so long as the parties consent to do so. The district court only tentatively explored and never exhausted that possibility. Instead, the court mistakenly concluded the alternative was foreclosed by the appellant's initial expression of that preference to wait and see if the 12th juror could be found. As we've explained below, the record does not support the court's conclusion. The expression of that preference slammed the judge door on the jury of 11 alternative. Yeah, so they say all things being considered, we prefer to have 12 jurors, but they weren't necessarily given that final opportunity. So this case is actually pretty decent for Karen Reed, to be quite honest. So I'm not sure it was necessarily as effectively argued in the briefing as it could have been, to be honest. It felt a little bit buried for my taste in the briefing. But this argument is better than I initially gave it credit for. So Karen Reed's odds are going up. And it's obviously based on the Constitution. I mean, they talked about the Fifth Amendment and all that stuff. So, there's that. When the district court discovered a juror was missing, it presented the lawyers with two options: either postpone the proceedings until the vanished juror could be located, or proceed with a jury of 11. As between these two alternatives, the appellant chose the former. So this is sort of this would be Karen Reed saying, yeah, in the previous things, we were given the option of do we want to have a deadlock instruction or not? We weren't presented with the option of, given that, what do we do now? Interesting. The court never offered appellant the choice between proceeding with 11 or accepting mistrial. To cinch matters, the court, during pertinent time frame, made no effort to ascertain appellant's attitude or wishes with regard to the possibility of mistrial. In view of these omissions, the record compels a conclusion that the jury of 11 alternative was not adequately explored. That conclusion is dispositive on this point. Where there is a viable alternative to mistrial and the district court fails to adequately explore it, a finding of manifest necessity cannot stand. And they seem to be saying that as a matter of the Constitution. They seem to be saying that as a matter of the Fifth Amendment. Yeah, this is in the petition for this case. This case is mentioned in the petition for the habeas. This case is mentioned in the petition, so it's present. Could have been a little bit better argued, but okay. All right, and then they're going to move on to the issue of consent, which I suppose we can talk about that as well. In the absence of manifest necessity, double jeopardy principles require defendant retain primary control over whether or not to abort a trial. With all, the protections of double jeopardy clause are at most serious a personal defense, so they may be waived or vitiated by consent. That brings us to the district court's alternative holding: the appellant consented to declaration. In this context, consent may be expressed, such as where defendant himself moves from his trial without having been goaded into doing so by misconduct attributable to the government. The requisite consent may also be implied from defendant's acts or failures to act, such as where defendant sits silently by and does not object to a declaration of mistrial, even though he had a fair opportunity to do so. Which is that the situation in this case? Did they fail to object? Is that the case here? Even so, the implication of consent is not to be lightly indulged. Any such finding must be consistent with defendant's valued right to trial before a particular jury and concomitant interest in deciding whether to take the case from that jury. In this interest, the district court concluded that the appellant consented to the declaration of mistrial twice over. The court first extrapolated consent from appellant's refusal to proceed with 11 jurors, which might be comparable to my extrapolation based on the request for the deadlock instruction. Maybe I'm improperly extrapolating, right? Maybe I'm improperly abstracting from the request for the deadlock instruction. For that reason, as previously discussed, we reject this extrapolation. Choosing to await the return of the missing juror over proceeding with jury of 11 cannot be reasonably construed as consenting to a declaration of mistrial. There's, however, more of this case. The district court also held that the appellant implicitly consented to the declaration of mistrial by silence when the court announced its intention to abort proceedings. The integrity of this finding presents a close question. As the district court correctly observed, defense counsel was present throughout. It did not object to the declaration of mistrial at any point. Under most circumstances, such silence might well permit a finding of implied consent. So maybe she loses on consent. Maybe she loses on consent, which is an interesting item. She loses on consent. But this case is different. Implying consent from failure to object requires that at a bare minimum, defendant had adequate opportunity to register an effective objection. And then they compare a case where implied consent was found, where defense counsel sat in a courtroom for several minutes during the announcement of a mistrial without objecting. Citing another case, rejecting a finding of implied consent where the trial judge, in a state of grief, after learning of the death of his family, abruptly ordered a mistrial and left the bench. Yeah, because there's no time, right? There's no time. So we're somewhere in between those two universes because they had like 30 seconds, right? Plus, of course, the time that they could have objected, when the jury was in the back room. Because the jury was still in the back room. They were still there. So presumably it could have been recalled. So maybe she loses on consent. Thus, the question reduces to whether defense counsel had a fair opportunity to object. District court answered the question in the affirmative. The court found defense counsel had several chances to voice an objection, as did Bev, as did the Supreme Judicial Court of Massachusetts in the parallel case. For several minutes after the court announced the decision to declare a mistrial, both defense counsel and government counsel remained in the courtroom. Defense counsel was present as the court questioned the courtroom deputy as to whereabouts of the missing juror. Next, defense counsel was present when the court expressed concern over the government's motion to set a new trial date. Finally, defense counsel was present at the court explained to them the reason for mistrial to the jury before discharging them. At no time from the moment the court declared a mistrial to the moment it discharged the jury, defense counsel object. We accept the court's factual findings. The defense counsel was present at all relevant time and lodged no formal objection. In the circumstances of this case, however, those facts tell only part of the story. And when in full panoply of the facts is taken into account, the district court's conclusion that counsel had adequate opportunity to object becomes insupportable. The dynamics of trial are important to its outcome. To do her job, a lawyer must be forceful, but she must also handle a relationship with the presiding judge with care. Nothing goes further to disturb the proper atmosphere of the trial than a lawyer's reiterated insistence upon a position to which the judge has once considered and decided. Fair enough. Like this is a bit of a delicate balance, and lawyers can't, just necessarily scream at the wind forever. It follows that when a lawyer repeatedly attempts to state their position but is repeatedly rebuffed, there will come a point in which further insistence can have deleterious consequences. A lawyer ought to be required to persist stubbornly when a judge has made perfectly clear they don't wish to hear what the lawyer has to say. In this case, defense counsel either made 2 or 3 attempts to be heard during the district court's sua sponte consideration of whether or not to declare mistrial. On each occasion, the court stopped counsel in their tracks, cutting them off once the court was addressing the issue of whether to wait for the missing juror, and twice more when the court was addressing the issue of manifest necessity. It was only after these 3 attempts to state their position had been firmly rebuffed, defense counsel lapsed into silence. To hold under these circumstances, appellant freely, albeit tacitly, consented to discharge would mock reality, at the same time condone an unfortunate curtness on the part of the district court. We do not think to consent manifestly can be inferred from this enforced silence. Let us be perfectly clear. We do not mean to say being silenced by a judge always correlates with an opportunity to object. Here, however, confluence of factors, especially the number of times defense counsel was stymied, and the relatively brief period of time that elapsed, militates in strong favor of a conclusion that consent should not be implied. With all due respect to the good faith of the district judge, who we do not doubt, the district court doubts it. The Court of Appeals doubts it. I'm telling you, they do. Right? We have no reason to question the district court. Sure. What are you saying between the lines? Right? Yeah. The district court is a good district court. Sure. That's what you're saying. With all due respect to the good faith of the district judge, which we do not doubt, we conclude the fundamental constitutional right of an accused should not be snatched away in such unfortunate circumstances. Consequently, we hold the district court's second basis for finding consent is untenable. That is the end of the matter. And in the absence of either manifest necessity or binding consent, jeopardy persists. Okay. So this case is actually a lot more helpful to Karen Reed than I first gave it credit for. So on the issue of manifest necessity, Karen Reed actually has a better argument than I gave it credit for. This is at least in part because of the way it was argued in the petition, which to my mind, at least, could have made this point better, right? The petition left a little bit to be desired on this point, relating to this issue. Let's see if we go back to where they actually argued it in the petition, because it was a little thin. Yeah. Okay, they cite those same three factors here. In this case of Garski, they cite those factors again. Embracing both consideration of alternatives and consultation with counsel and the amount of time devoted to judge mistrial, a precipitous decision reflected by rapid sequence of events culminating in declaration of mistrial tends to indicate insufficient concern. Yeah, so if they just sort of declare mistrial from out of the blue, if they declare it, with no warning whatsoever, no opportunity to be heard, that's a problem. Okay. And then they sort of they say there's no consideration of alternatives. Okay. And then they cite this First Circuit decision in this helpful analog. The First Circuit reversed findings a clear alternative mistrial proceeding with 11 jurors, while district court attentively explored the alternative and never exhausted it. The court never offered defendant a choice between proceeding with 11 or accepting a mistrial. In fact, during a pertinent time frame, the court made no effort to ascertain defendant's attitude or wishes. In view of these omissions, the record compelled a conclusion jury of 11 was not adequately explored. This conclusion is dispositive because where there's a viable alternative mistrial, and this reflects even less alternate consideration. Okay. I mean, they have a case. They have a case. So I need to up her percentage chance from the 1% that I gave it, because that's no longer a fair assessment. Okay. So how do I reassess the balance of this now? Well, the consent issue is a problem. On the manifest necessity ground, it's pretty close. Although, yeah, because the court didn't give weight to alternatives, didn't consider them explicitly. There was really no discussion of alternatives at any point. There was no discussion of alternatives to mistrial at any point. So there's nothing on the record showing the court considered anything. So as to manifest necessity, I think that Karen Reed has a winner in view of the precedent from the First Circuit. Massachusetts is part of the First Circuit, right? Where's my circuit map? Yes, Massachusetts is part of the First Circuit. Okay. So yeah, this is authoritative precedent on the constitutional issue. And there was also that case that said in the case of double jeopardy, they don't necessarily need to wait. So I think the odds for Karen Read go up. I think in no small part, it will help a lot if the U.S. attorney gets involved in this on Karen Read's side. That would make a huge difference practically. So I'm not even sure who the U.S. attorney is at the moment, because of course we've just had a reshuffling of that due to the new administration. So I'm not sure what the new U.S. attorney would think about this. So, the U.S. attorney, if they decide to get involved and provide an amicus, I mean, they can't get directly involved, but they could submit an amicus petition or an amicus brief. If they decide to get involved in this, that would probably go a long way either way. So it'd be interesting to see if the U.S. attorney decides to pick this up. That would change the odds. If the U.S. attorney decides to intervene on Karen Read's side, that would change the odds a lot in Karen Read's favor. The U.S. attorney getting involved alone would shift the odds dramatically in her favor. So, but as it sits right now, without the U.S. attorney's involvement, is that Pam Bondi? No, Pam Bondi is the attorney general. The U.S. attorney is, I don't know who the U.S. attorney is. If the U.S. attorney general got involved, that'd be even more persuasive, but probably not. No, this is a little small for the attorney general. But not necessarily for someone from Maine Justice. So if someone from Maine Justice got involved, that would also be interesting. So let's just broaden it out. If the Justice Department gets involved in a broader sense, that will be interesting. But as it sits right now, what are the probabilities? The consent issue is not good for Karen Read, I don't think. I mean, it wasn't minutes, but it was 30 seconds. And as been pointed out, the jury was in the back room. So although they had been dismissed, they're like right there though. I mean, I guess we could undismiss them because they're like right there, right? And it's not like they're going to be discussing things beyond the case anyway. So presumably we can go grab them. So I think the time factor is the hugest problem for Karen Read now. I think consent is actually the biggest problem. And I think she loses on consent because they had time to object. They had they had 30 seconds, from the time that the judge was bringing the jury into the room, and they had time while the judge was reading the note, and they even had time when they were discussing rescheduling, presumably to raise the issues. I think they lose on consent. So I think on balance, Karen Read still loses this argument. I think she wins on manifest necessity, but loses on consent. So I think the odds are less that the district court now decides to abstain. Although I think that's still a really strong possibility. So I think maybe the odds of abstention are now like 40% to abstain. And I think the odds of Karen Read winning are like, I don't know, a third. That's probably high. 30%, 25%. Yeah. Of course, a lot depends on the judge. A lot depends on any further briefing. But yeah, her odds went up from 1%. Her odds went up from 1%. So they're like 30% now, maybe. But the consent's a killer at the moment. The consent's a killer. So, yeah. The 30 seconds is where they should have objected after a mistrial is declared? Yeah. Yeah, that's where they should have objected, right? After the judge said I'm declaring a mistrial, they should have said object, yeah. And that might have been sufficient opportunity to object, yeah. Based on what we just read in this case, it seems right. This trial is already declared. Well, they hadn't dismissed the jury yet. I mean, so they could have been like, I object, I'd like you to consider something else. I mean, the jury had not been dismissed. So like, if she had said, I'm declaring a mistrial, and they said, no, I don't want to, and he said, okay, I'm changing my mind, no mistrial, then I think the judge can do that. The judge can always reverse their own decisions, unless it's too late. So if the judge says, I'm going to declare a mistrial, and then you're like, I object, and you're like, okay, I changed my mind, then all right, then we're just carrying on. Yeah, I think you could object. I don't think there's anything that, I don't think it necessarily like locks itself in place for all of time once the judge just says a mistrial. I don't think that necessarily, brings everything to an immediate screeching halt. I think there's a little bit of lag time in there. Can I read the Supreme Judicial Court response? Have they already responded on the docket? That'd be cool. Have they already responded on the docket? That'd be cool. Let's take a look. Butterfly in the sky, I could go twice as high. Take a look, it's in a book, reading rainbow. I can go anywhere. Ways to know, reading rainbow. Thank you, Torin, for rating, by the way. Appreciate the raid, as always. Those are nice things to do. Now I have to find it. Okay, wait. I have the case number. I can just pull it on Pacer. Pacer kind of sucks except for all the other things. I'm grateful Pacer exists every single day because state systems suck. Pacer kind of sucks, but state systems suck harder. Hey, Torin, you here, by the way? Actually in chat. Hey, I just wanted to let you know that I never received your thing that you made for me. So I don't know if you ever sent it or not, but I never received it. So I just wanted to let you know that I hadn't received it. So I don't know if you sent it. So I thought I should tell you. So. It'll be going out in the mail a few days? Okay, that's perfectly fine. I was concerned that you had mailed it. I'm not concerned about that. I was just concerned that you had mailed it and it got lost in the mail somewhere, and I was very upset. So that's perfectly fine. Obviously, you can take as much time as you want. Response to court order by Karen Reed. There's a chief judge service order. Okay. Response to court order. So it doesn't look like there's a response yet. Yeah, there's no response from the government yet in response to this thing. But we will keep our eye out. We will keep our eye out for a response from the government in terms of this petition. Response is due on the 26th. Yeah, that makes sense. Yeah, I didn't think there would be a response already. That seemed fast. But we'll cover it when one is filed for sure. Oh yeah, my address is on my LinkedIn page or my tree page. It's on the tree page is the address. Linktree. Okay, cool. All right, questions, concerns, comments. Are hearings set on every habeas petition? Unless they're completely dismissed out of hand, which is a little unusual. Yeah, I mean, it's a little unusual for petitions to just be completely dismissed out of hand. Usually there's at least a hearing on petitions, unless they're like, soft sick crazy or insane or something. So like if there's any sanity to them at all, yeah, you'll typically at least get at least one hearing on it. So yeah, the fact the hearing is scheduled doesn't really mean anything to me. It doesn't indicate anything to me. Are there any questions, by the way, or any thoughts or comments? But I think this First Circuit petition is better than I initially gave it credit for. But the consent issue is a killer. It's a problem to say that there was no opportunity to object, no opportunity to be heard. It's that they sat on their hands. I mean, they sat on their, and like even after the judge technically dismissed the jury, I'm like, they're just sitting in the back room though. Like, they're just sitting in the back room. Can we undismiss them? I'm like, I don't know if we can, but I'm like, no one even thought to ask. It's like, I don't know, right? Yeah, the consent issue is a problem. Yeah, they were waiting for Bev to go back there and talk to them, so she could have easily pulled them back. Yeah, jury was tainted. Yeah, I don't know if the jury was tainted. Tainted by what? Right? Tainted by what? In that few minutes, tainted by what? Right? I mean, unless they had their cell phones on them and were immediately pulled up their phones and were like already browsing the webs or something. But if the question was, wait, were you guys in fact unanimous? Right? If it's merely to poll the jury, like I don't know that being tainted would necessarily skew that, but I don't know. It didn't happen, so it's an interesting alternative. The decision to seem to cover a judge like Kennan mentioned defense would not want to defy the judge openly. Yeah, this is a little different though, because like the judge hadn't like said like, shut up, I don't want to hear you or anything like that. Like every time counsel asked to be heard, she heard them every single time. I don't remember that kind of friction in the case. I don't really remember a time where the judge was like, I mean, the judge was ruling against them, but I don't remember a time where the judge was like, sit down, shut up, don't argue, don't open your mouth. I don't remember anything like that. So I don't think that kind of hostility was present in that sense. Yeah. She sustained all objections. Well, I don't know if that's true. I don't think that's true. But either way. But we're not here on bias, right? So we're not arguing bias today. So like that issue is immaterial for the moment, right? Whether the judge is biased is not the issue on the docket. So you can throw that issue out of consideration, right? You can throw, was the judge biased? You can also throw out, was the foreperson biased? You can throw out those issues because those are not the issues being raised at the moment. She told them to speed it up. Well, she wants to get the court moving along at a reasonable pace, and I don't blame her for that. I don't want to dilly-dally around either. So I'm not sure that, let's get this thing moving is hostility either. As a judge, I'd want to keep things moving. I'd get pissed. I'm in favor of chess clock, as we've discussed, right? You give a set amount of time for each side, and that's how much time you use. Now, chess clock in criminal law might have some implications. So I remember one case where there was a case, and I couldn't quote you, chapter and verse, but I remember a case where they did do chess clock in a criminal case, and the defense burned through all their time, and so the judge wouldn't even allow them to cross-examine like state witnesses. It might have been during the rebuttal case, I don't remember, but by then they had run out of time. So the state was bringing rebuttal witnesses, and the defense is like, I have questions, and the judge is like, no, you don't, because you don't have any time left, lol. And the court of appeals in that case reversed, because they're like, well, while we do appreciate the joy and love of chess clock, there is a right to confront the witnesses against you. So you had to give them some kind of opportunity to ask questions. Now, the way it was written, and I'm going off memory, right? But the way it was written sort of seemed to imply that, like, even if you gave defense counsel like a fairly minimal amount of time, like even if you gave them like 3 minutes, that might be enough. Now, it's 3 minutes you didn't have left on your clock, so I'm giving you another 3 minutes to ask questions. But like, even if you gave them a de minimis or a relatively minimal amount of time, that might be legally sufficient. But to simply say, no, you get no further questions because you ran out of time, there was at least one appellate court that said you couldn't do that. There's at least one appellate decision that said you couldn't do that. So I'm not opposed to chess clock, perhaps with modifications. Even in a criminal case, I'm certainly not opposed to the judge saying, let's get a move on, let's get it going. I don't want this case to last any longer than it has to be. It's like, do you really want me to? I would really, all things considered, not like to be here for 6 or 8 weeks. That does not sound like my fun time. I'd like this to be over. Like, how about a trial in 3 days? Can we do that? Right. So I don't necessarily fault the judge for wanting to expedite things. That is not one of my stronger criticisms. Now let's move. Let's go. Yeah, we'll have to have a determination as to whether it was snowing all over again. Yeah, I could have done without the was it snowing argument. As the judge, I would have been like, can we please stop introducing evidence as to whether it's snowing? It's like, will defense just take judicial? Can I please get the defense to agree and take judicial notice that it was in fact snowing? Can we agree on the snow, please? I don't want to hear more evidence about the snow. It was snowing. I've seen videos of the snow. I understand it was snowing. We can move on to other things. I'm ready to move on to other things with my time. But the prosecution was unable to produce any of the snow in court. I'd like to take note. Right? They say it was snowing. But where is this mysterious snow? Why haven't they provided any of the mysterious snow in the courtroom? Why don't they bring the snow into the courtroom and show the court the snow? Where has the mysterious snow gone? Lol. What do you mean it evaporated? Man. Well, the fact that Judge Sala still serves the first district improve Reed's chances as to the specific judge. I don't know. I don't know enough about the specific judge to factor that into the equation. I don't know. Yeah, if you knew a lot more about the judge, you might be able to change your odds substantially. So if someone's like, yeah, I'm really familiar with the judge in addition to everything else, and I'm going to skew the odds accordingly, it's like, that's totally fair, right? If someone was like, I know this judge, and I'm telling you, based on this, there's like an 80% chance she's going to do this. I just know the way she ticks. I'd be like, okay. I mean, I can't compete with that, right? I don't know the judge personally. I'm just assessing in the dark. I'm assessing, any random judge. I'm assessing based on the reasonable judge, the reasonable, prudent judge, not necessarily the judge that's actually hearing this. Yeah. But if the district court doesn't get involved, we get to watch this trial all over again with potentially new and exciting witnesses, and also potentially with sanctions against the defense. Will ARCA be allowed to testify the second time around? That seems to be suspiciously the direction we're heading in, doesn't it? right? That seems to be the direction we're heading in. That ARCA's not going to be allowed to testify the second time around. That seems like what Judge Cannon is teeing us up for. So, brace yourselves accordingly. Brace yourselves accordingly. There seems like there's a non-zero chance that as a result of Tuesday, the judge is going to say ARCA is not allowed to testify anymore. Based on what? I don't know. Right now, that would be the real question. Like, why is she saying that? Would be the real question, because that's a fairly severe sanction to disallow the witness to testify. I mean, it is a sanction that's available. It's something a judge can do. It's an abuse of discretion analysis. But like, why would the judge be doing that? What is the basis for their decision? So, but it seems like we're teeing up in that direction. Say I wrote the decision in that missing jurors case. That's pretty cool. So this is Judge Dennis Saylor who wrote this, who's been assigned to this case. So not Judge Celia, but Judge Saylor. So the fact that the other judge is still there, I don't necessarily think it's going to necessarily mean anything. The jury didn't give ARCA too much credence in trial one. It certainly seems that way, although I would again caution you that really doesn't mean anything per jury number two. Right? That doesn't mean anything per jury number two. And I sort of forget where I heard the story once. I forget which defense lawyer said it to me. But I remember a defense lawyer saying about a case. They tried a case, and I think it resulted in a mistrial, because otherwise the story makes no sense. So they were trying a case, and it resulted in a mistrial. And the jury said, like, why didn't you talk more about this leather jacket? Right? So there was some sort of leather jacket that was a piece of evidence that was relevant to this thing. And the jury person who talked to them was like, why didn't you talk more about the leather jacket? I wish I knew more about the leather jacket. The leather jacket, you didn't spend enough time on it. I wish I knew more things about it. And so that lawyer then, when the case was retried, took the advice and spent more time talking about the leather jacket. And then when the second jury got interviewed, they said, why did you spend so much time talking about the leather jacket? We didn't really care about it. Why'd you keep talking about it? We didn't care. So like, what one jury will choose to care about and another jury will choose to care about is dust in the winds, my friend. It's dust in the winds. So apparently Karen Reed jury was not all about the defense expert life. That's not what they were interested in. They were not interested in the ARCA experts and their defense. Apparently they were more interested in Trooper Paul, which makes my soul hurt a little bit. But what can you do? But they weren't about that ARCA life. But that is by no means any indicia about what this second jury will think. Second jury is an entirely new jury, and what they will choose to care about are whims best left unspeculated about. Can they bring the ARCA evidence by transcript and evidence? Now, if the witness is disallowed, they can't. No, not if the witness is disallowed, they can't. The witness is disallowed, that testimony is gone. So, yeah. Jury picked from the same community? Of course, it has to be. Yeah, jury has to be picked from the same. Well, I slightly overstated. The jury has to be picked from the same state by law. But yes, it will be picked from the same community, I would imagine. I haven't seen any motions to change that. So I would imagine the jury is going to be picked from the exact same community as the first jury. So that would be my presumption. Yeah, probably from the same county. Yeah, they don't like to do it if they don't have to. Yeah, same county, which includes the town of Cannon. Yeah, it would have to. I mean, it would have to include the town of Canton. How would it not? That's the place where the crime occurred. The jury pool would have to include the town of Canton. Yeah, of course it includes the town of Canton. That's where the crime occurred. That's the venue. So yeah, of course it includes the town of Canton. I can't wait till Tuesday. Tuesday should be pretty lit. Tuesday should be interesting for sure. Bev would send Karen Reed to the electric chair if she could. Yeah, I don't know necessarily what's going on in Aunt Bev's head, and I'm not sure I want to figure it out. I have better things to spend my time on than trying to figure out the machinations of Judge Bev. She seems like she's a little close to the case. Recusal seems like it might have been a preferable option. You know? Defense should try to accuse the judge again? Yeah, why not? Raise the issue again, sure. How do I find anyone who doesn't know anything about this in Canton? Well, I think that might be slightly easier than you give credit for. While it is a relatively large news item, I imagine, there is a not inconsequential amount of people who just go about their life in a day-to-day basis and don't really pay any attention to the news at all in any sense. And also there's a lot of things just happening in general. There's a lot of things for people to pay attention to, right? So, there's probably jurors who are not particularly aware of this case. Now, jurors who've never heard of it, yeah, there's probably some of those too. But to be like, yeah, I heard a passing reference to it, but it doesn't mean anything to me. It's like, that isn't that unbelievable. It's a large item. It's a large news item. It's more well known in the community than some, but probably the majority of the community, if not more, probably doesn't really particularly care one way or another. I mean, there's a very serious faction of people who care, but probably most people are just going about their lives and worrying about their bills and where they're going to get their food from and so forth and so on. So I think finding an impartial jury might be slightly easier than you're anticipating. Anything else I can answer while I'm here? Or should I just end the stream? I'm enjoying spending time with you, so I'm not in a hurry to end the stream if you guys want to keep carrying on. Did they find the juror in that case we read about? I don't know if they ever found them or not. It wasn't in the case that we read. So jurors just gone somewhere. We don't know where. Why is the so-called federal investigation still pending? The federal government is extremely conservative, generally speaking, about bringing charges. The U.S. attorney, as a general rule, is more conservative in bringing charges than your average state prosecution. They really don't like to lose, right? There's a reason that the U.S. attorney has a 99% conviction rate when you factor in plea deals, right? Even without plea deals, it's like 92, 93%. They really don't like to lose. They really don't like to bring charges unless they've got you like 5 different ways. So the U.S. attorney tends to be, as a general rule, extremely conservative in bringing charges. And the FBI, as a general rule, tends to be very conservative in bringing charges. So, and you don't know that the investigation is necessarily still going on. The investigation might be over and they just decided not to bring charges. So like they couldn't, at least to their own satisfaction, find anyone to prosecute. Which, given the overall tenor at the Department of Justice is, fairly reasonable belief. What makes you think they'll disqualify ARCA? Well, just the way the judge reacted and what she said. I don't know why she would do it. I don't know the basis of it yet. I don't know what basis they would disqualify ARCA, but that seems to be what she's teeing up. Right? Because this whole thing blew up about ARCA. This whole thing blew up about ARCA and what the defense might or might not have done with respect to ARCA, and she has grave concerns that might impact the defense and all the rest of it. So it's teeing it up to disqualify ARCA. That seems to be where this is heading. Now, why she would do it, I don't know the basis of it, and I don't know whether or not that's a legally sound basis. I don't know the basis of it, but it's like that seems to be what we're heading towards. That seems to be what the direction that things are moving. Julia, you had a question. What was your question, Julia? Let me see if I can find it. Should Bev grant motion to dismiss on March 5th to get herself out of being involved without the spotlight of recusing? Should she dismiss it? Legally? I mean, are you asking me a legal question, or are you asking me like a real political question? If you're asking me a legal question, I'd probably say no, she shouldn't dismiss it, because the standard is prima facie, and there's enough evidence here for a prima facie. It's like all you really need to do is believe Jen McCabe that said, I hit him, right? So that would be a confession, and that would be sufficient. So on a prima facie, should she dismiss it? No. If you're asking like on a real politique, should she do it for pragmatic reasons to get the spotlight off her? I don't think she's concerned about that. I don't think she's concerned about it, and I don't think she needs to be concerned about it legally. I mean, she has absolute immunity as a judge, and so in the absence of like, at least within her judicial role, of course, within her judicial role. So in the absence of her doing something outside of her judicial role, she has no reason to be afraid. She obviously doesn't care about the spotlight. Every light's already looking on her anyway. We're already deeply critical of her. What does she care? She doesn't care. She's just going to sit here and do her job. Which incidentally, by the way, like from first principles is a good thing, right? Judges really shouldn't care about the spotlight. Judges shouldn't be afraid of the spotlight. Judges shouldn't really care about the media and what people are saying. They should just make the best judgments they can that are legally sound. So that's what I think. All right, guys, I guess I'm going to go ahead and sign off for now. I've enjoyed this slightly deeper look into some of these issues. This has been interesting. So I think Karen Read has a shot. I think consent is now her weakest area. I think it's still more likely than not she doesn't win. I still think it's probably if this is argued the right way, I think the court might get involved. I think the federal court might make a decision on the merits. So I think the merits decision might be more likely now. There's still a pretty decent chance, though, they still decline to hear it, though, on abstention doctrine. There's still a pretty decent shot of that. But I don't think it's quite the landslide it was before. All right, guys, I'm going to go ahead and sign off for now. I hope you guys have a good time or a good day. And if there's anything else, of course, you want me to discuss, you can always catch me on my Discord. That's a good place to find me. It's a good place to suggest stories. It's a good place to inform me of new document drops. So if there's a new document that drops in a case you want me to cover, it's a good place to let me know about these new document drops, because obviously I can't pay attention to everything. So when people inform me of stuff on my Discord, it really helps a lot to let me know there's something for me to cover. And we'll go from there. Until later, my friends, I hope all's well. Cheers, my friends, for now, and goodbye.